I think everybody knows a little bit, perhaps from a real biased point of view, about what's happened to you lately, that you've had your bar license revoked and that you can't practice law anymore. Can you tell us just a little bit about how it started?
Sure. I began working as a division chief for Andrew Thomas when he took over as county attorney's office, and I believe it was 2004. And I interviewed with him, and he promoted me to a division chief. And one of the reasons that he said he did that was because the bureau that I was in did a lot of trials. We were very successful, and we had a very good reputation. The pretrial division was very challenging because it included all the grand jury and all the charging. So a lot of upfront work and a lot of the regional court center cases where we tried to resolve cases in volume upfront to try to give people a chance to move on with their life quickly, usually through a probation type plea. Sometimes there was diversion, especially with the drug offenses. We could get people treatment that needed right away, and that was another thing that was under my watch.
So in other words, one of your duties was to try and save the taxpayers some money and save some pain for the families of the accused and the accused themselves by seeing if you could divert them into probation or maybe get them to take a plea rather than to do a full-blown trial.
Absolutely. We had different programs. For example, we had the TASK program, which was a drug diversion program, which allowed people to basically get rid of their felony if they completed all the drug treatment, because a lot of criminal cases start with people using drugs, and that's very important to deal with. One of the other things we really focused on was getting cases resolved quickly, because a lot of people sit in jail, whether they're guilty or innocent, until they get to trial. So moving a case along further not only saves the taxpayers money for incarceration costs, but it helps people get things resolved more quickly so they can get on with their lives.
Did there come a time when County Attorney Andrew Thomas perceived that there was corruption in high places in Maricopa County government, like for example in judges or county supervisors, and he asked you to do something about it?
One of the big fights, I guess you would call it a fight with the judiciary, Mr. Thomas, was over the bail status of illegal aliens. And what was going on was the courts did not want to enforce what the voters had voted to do, which was to hold illegal aliens without bond until their case was resolved. And again, that kind of fed right into our goal of getting the cases resolved quickly so people could move on with their lives. But still, the people needed to be protected because this person wasn't here legally, and the courts didn't want to enforce it. So there was a lot of tension and a lot of concern about why the courts were not following the law.
So do you think maybe this was the origin of the friction and tension between Andrew Thomas and the judiciary and perhaps other people who wanted to go to bat for bail for illegal aliens?
That was definitely one of the catalysts. The other one was that Mr. Thomas had basically kept in place Mr. Romley's policies for pleas, but made it a little tougher. He also, though, when he made those pleas tougher, he also allowed for a deviation practice that was entrusted to the line supervisors so that people could be looked at on a case-by-case basis, and if a policy needed to be changed, a plea needed to be given that was not appropriate for the policy, it could be given at different levels.
Was that something that was up to the individual judgment of the, what did you call them, the line chief?
There are line supervisors, and then there are supervisors of that supervisor, and a lot of times it just depended on the type of case. If it was a more violent crime, for example, then there needed to be other approvals. But a lot of times the line supervisors could give deviations. And Mr. Thomas wanted to let the people that were in the know, for example, that were familiar with the case, make those decisions.
So, in other words, he allowed his employees a free hand up to a certain point to dispose of cases in the best way that they saw fit, based on saving money for the taxpayer, protecting public safety, etc.
He did, but what it did was cause the judiciary to really not understand, and they just saw that the policies seemed to be tougher, and they didn't like that, because they also used to call Mr. Romley when they decided that it was important to do so and get a better deal for someone. Mr. Thomas didn't feel it was appropriate for a judge to be trying to influence a prosecutor to give a deviation. And it also resulted in that type of case in the normal Joe street sweeper who was charged with the crime being treated differently than someone who had a high-powered attorney who was able to obtain the influence to get the judge to make that call.
Aren't there ethical rules prohibiting that type of ex parte communication?
Well, usually it wasn't ex parte because the defense attorney would either be involved or would be behind the judge calling. But arguably, yes, it is not appropriate, and Mr. Thomas didn't think it should continue to happen.